Hello, everyone, and welcome to the Jus Commune podcast. My name is Emilia Mataix Ferrandiz from the International University of Catalonia in Barcelona. And here today I have the pleasure to interview Professor Yair Furstenberg, who is a professor and chair in the Talmud Department of the Faculty of Humanities at the Hebrew University of Jerusalem. His research focuses on the history of early rabbinic literature and law against the background of the Second Temple Judaism and within its Greco-Roman context. His work traces the emergence of this new legal discourse in the literary evolution of the Mishnah. He has reflected on these issues on his book, Purity and Identity in Ancient Judaism, From the Temple to the Mishnah. But today we are going to be talking about his new project that has been on the works for some time, that deals with the impact of the broader Greco-Roman culture on the evolution of rabbinic law and thought. His recent ERC project that is starting, as he has told me, next week is called Local Law and the Realms. And he's talking about how his research has expanded of provincial legalists through a comparative examination of various local legal cultures in the Greek East. So welcome, Yair. Shalom. This is the only work on Hebrew, I know.
Shalom. Pleasure to be here.
Thank you very much. So just to start, help situate our listeners, can you provide an overview of the historical and legal context of the period you are studying?
Yeah. The current project, and I would say my work as a whole, focuses on legal discourse during the first, I would say, 3 centuries CE for multiple reasons. There are specific rabbinic reasons within Jewish law. The fact that the rabbinic law was created during this time. This is the end of the Second Temple, the destruction of the Second Temple, and the Judea becomes a Roman province. And at this point, the rabbis develop their rabbinic law, a system of rabbinic law, which we'll have more to say about later on. But more importantly, beyond the rabbinic framework, talking about the Roman Empire, these are, I would say, these centuries stand at the heart of our understanding of Roman imperial legal culture as a whole. Once we get to the 1st century BCE or 1st century CE, there's already a Roman Empire. There are provinces. There is a judicial administration in the provinces. There's a system of administration and the way the law works in the provinces. But at the same time, we're still at the stage where we can talk about, and this is the main category we will use, we'll talk about legal pluralism, in the sense that Rome is not imposing its own laws upon its inhabitants, and it allows local systems, local communities to maintain their traditional legal system and practices. And here we encounter the question, which is at the heart of what interests me, is how do these cultures maintain, or how do they manage this multiplicity of legal systems, where at the end of this period is the 3rd century, which begins with the Constitutio Antoniniana that makes all the inhabitants of the Roman Empire Roman citizens, yet they still maintain their own legal practices. So there is a long process of local communities fitting into the Roman order, but at the same time, they're still negotiating. So these 3 centuries, the 1st to the 3rd century, I think are the most interesting if what we're asking is, what is the relationship between the periphery and the Roman center, and the relationship between different orders of law?
Well, thank you. And you're touching upon so many different topics. Well, first of all, also talking about Constitutio Antoniniana, that is this kind of elephant in the room that is there. And, I'm not going to start with that. But you touch, for example, on the big important field of legal pluralism. And as we know, this all started somewhere. And it started with this dichotomy of empire versus the provinces, in which, the people like Medes at their time, they were having like a strong preoccupation with unification and the model of a state, and they were talking about this idea of Rome coming from top to down and, like imposing their law to their subjects. So since you have introduced this topic, can you say, where are you starting on this? Are you taking these debates on legal pluralism that, changing them, deconstructing or something like that, or evolving from there?
Yeah. Okay. So there's a lot to to deal with here. So first thing, I mean, legal pluralism is a fact, and is, I would call it a policy, right? We can deal with it as a fact, meaning there are multiple legal orders in the same space. People are exposed. They can use the different systems, and this is something that is essential for the way Rome acts. After all, we should remember that jurisdiction is a major component of provincial administration. One of the major roles of the Roman governor is to offer, I would say, legal service to his constituency, to the people of the province. Now, what will be the way to provide this service? So while we could have assumed that he would like to impose the Roman law because he sees that as the correct system or the best system, it's on that. He's also interested in maintaining the difference between the citizens and non-citizens. So if law is the thing that signifies the borderlines between different communities within the Roman Empire, we have to maintain. Right. So it's not only a matter of fact that we have multiple practices. We, as the Roman governor, must maintain in order to show who is set in what level within this hierarchy of this empire, who is Roman and who is a non-Roman. At the same time, he must provide the service of law to the people of the province. So the way to do it is to monopolize jurisdiction, but not to monopolize the legal system. So whenever you would, and this is a very complicated issue, because within the Roman Empire, each place, each city, each province has its own system or own way to deal with this. And it's a patchwork. We would say it's a patchwork of multiple practices, in a sense that we can, just to give an example, there would be the Greek cities that had their own law, their own autonomia, right? Their right to follow their own laws and have their own courts of the local citizens. But on the other hand, you would have in Egypt where the governor would head the legal system. There were no local courts that were recognized by Rome, but everybody, when coming to the Roman governor, could apply and ask to apply their local law, the laws of the Egyptians, we know this term. So here is a complicated situation. You come, right, as a litigant, you come to the judge asking him to apply your own system, because that's the thing, that's the most stable way to act according to your tradition. On the other hand, he has his own way to interpret it and to evaluate this system. And what he would do is he would many times choose some way in between, or you would try to, on the one hand, hold your own traditions and try to show yourself the best you can to the Roman from his own terms. So this creates a very complicated interaction between litigants, between Roman judges, between legal experts, right? And all of this is taking place at the time when Roman law itself is evolving. It's not a set closed system. We're talking about the first and second century, when we're talking about the height of Roman jurisprudence, and we still don't have the systematic legal literature. The writings of the jurist are just being created. So here we see this complicated situation, and now I think the question that all scholars, are asking themselves, right? What are the main forces that are active on this situation? So you can talk, and we can use various terms. We can use in the notion of Romanization, right? We're trying to make the provinces more Roman, right? And we're not doing it directly. We're not imposing, but we're showing them that they should become part of this Roman legal administration, and use it and enjoy it, and try to systematize their practice according to Roman standards. And we can talk about a more current terminology would be that of provincialization, meaning that each local group has its own way to negotiate these powers from above and from below.
Yeah, well, here again, you're touching a lot of different topics, including, the term Romanization, that is this kind of hot potato as well.
Right, sure.
I'm surprised that we didn't even use the term post-colonialism, that is now current in every kind of ERC proposal research that is there. But I'm very happy that you mentioned, jurisdiction and the Roman officers, because also it brings me to my next question, that it's, one of the things that I find most interesting about your project, in my view, is you are telling that Roman law actually helps develop rabbinic law. It has an impact on local law. It's not only coming, and having this kind of solo gig, and being offered to the locals, but also having an influence on their practices. So in that sense, because now you have talked about this different complicated issue of Roman officers and locals asking for some practice. So in this, this influence of Roman law on the local law will be driven then by a mixture again of the state, privates, combination of both in that sense as well, or what do you think?
Yeah, so you can. I wanna distinguish here between two basic approaches that helped me sharpen my own view on this topic. One would be a very localized approach, in a sense, or a very personal, individual approach. Maybe I should even say individual approach, in a sense that each case we should identify all the participants and their background, their traditions, what they bring with into this exchange, and the unique result, in a sense. And the best example is that the case of Babata. And I must mention the work of Kimberly Tchaikovsky, who wrote the book and wrote articles. And she very clearly formulated this idea. She called her book Localized Law. But in a sense, it's on one level, and talking about post-colonialism, on one level, it heightens the agency of the local participants, in a sense that it's not only a matter of what the Roman judge will decide and what he allows you, what system of law he allows you to relate to. No, but the local litigants already, from their own initiative, try and assume what kind of practice would work the best for them. So they will create, and Tchaikovsky shows that in her work, they would create documents which don't make sense from a Roman point of view, a pure Roman legal point of view. For example, some kind of mixture between stipulatio and bona fide, and they'll create a formula which connects the two things, when it doesn't make much sense from a Roman perspective. But of course, it's something that if you want to look Roman, that's exactly what you're gonna push into your documents, exactly these kind of ideas. So what is against a system, and this is a very crucial point. You focus on the participants, you focus on the agents, and it comes in instead of or you somehow disregard the law as a system, because now we're not talking about Roman law, right, or Greek law or Judean law as a system, because the agents are not aware. They're not jurists. They're not aware of what defined. They just take specific practices which seem to them that would work best. Right. So this is one approach, but I think it's very popular now among scholars to break down the notion of law as a system and focus on the role, the agency of specific agents. Would include the Roman judge, would include the litigants, would include also local experts, right? You still need an expert. You go to an expert to write the document, to give you advice, to find the relevant document within the archive. This is a major element of our understanding of the kind of dynamics we're coming into court, and we don't know exactly what the principles are. Okay, so we'll go to the archive and try to make our case the strongest case. Since I come from rabbinic law, right, I'm not rejecting the previous approach, but I want to think more seriously about local law, not as a set, an accumulation of various practices which you pick and choose according to what is good for you in the specific case, but as a system that on some level reflects your own cultural heritage, your own self, in a sense. It's you. I want to compare it to a famous position of Greg Wolfe, who wrote about this issue of Romanization and provincialization. And he had he had an article, right? Being Greek, becoming Roman, or something like that, right? How can you be both Greek and Roman at the same time? So he says, look, we have a problem. He doesn't focus on law. He focuses on other aspects. And he shows, look, there are elements where you see that Greek elites are completely open to Roman, to the Roman environment. They participate in Romanized urban culture very strongly, right? They're part of the urban culture, the civic culture. But on the other hand, they're very, very much opposed to specific cultural elements. They try to highlight, right, the Greek, how much Greek they are and not Roman, right? And they see that as a point of contention. So what he says, and it's a crucial point, and which I think is very helpful here. What he says is, it depends how much you view this Roman culture as undermining your own culture. So in areas where Greeks don't have any architectural, we would say, heritage, or it's not a strong thing that defines their own self, while literature is a very strong element within Greek identity. So the same thing, I would say, let's see law as the same kind of cultural arena. What areas of law are more sensitive, in a sense that adopting Roman practice is something that is not simple. It goes against your own culture, your own definition, the way you define yourself, your group, etc. And what areas are more neutral, in a sense, and you can adopt, or you can integrate into the Roman system more freely. And the rabbis, in a sense, are a fantastic test case for this perspective. And here begins my own project, because the rabbis are creating their jurists, right? We see this is a unique case within the Roman provinces, when we're not relating to, or our evidence is not that of court, relating to court procedures, such as documents or proceedings rulings, or etc. This is a juristic literature. This is a unique local juristic literature, meaning that we have this literature encompasses all fields of law. So it allows us to compare the development of specific fields to compare different fields and their development, and to see to what level do they adapt to Roman practices. Do they offer maybe an alternative to Roman practice? Where, in what sense do they try to fit into, I would say, a Roman discourse or forms of thinking and legalism? So rabbinic law, because it's a system, and again, I don't know how people felt about it, but at least Jewish tradition views itself very clearly as a system of law. And now we can ask ourselves, okay, having this, and clearly for them it's significant, culturally significant, maybe even at times religiously significant. So how do they deal with the integration into the Roman order? And the additional aspect, once we begin our journey from the rabbinic perspective, as in the way I did, so suddenly it's not a mere chance that we find in the specific documents are more Roman and specific documents are less Roman. No, we can try to make sense, try to see again what not the personal interest, but the cultural impact or cultural weight of this, and then comparing the different systems. So my project, Local Law Under Rome, seeks to really examine, again, much work has already been done, and we're completely relying on earlier works. But I think that on two levels, there's still what to do, which we seek to complement. One is to really gather all our data on local practices and check the level of integration into the Roman order, and think of it not as local case by case, from a case by case perspective, but what do these decisions or policies on the local level teach us on the ways of integration of these communities into the Roman order?
I think that is very innovative, and I think it's good because it's true that in the past sometimes we were looking at documents and it's like looking for a typo, right? Like, is this Roman? Is this not Roman? What do I see? And the thing is, like, what I find more fascinating is you're talking about people, how actually people are doing stuff. Because I mean, many of these people, maybe they were assessed by, this expert who will say something, and you will go to a Roman officer that maybe doesn't know how, like local law works. And it's like, well, we have the example of Pliny, like sending letters, like, how do I do this actually? What I want to introduce is the topic that you have used in your work, this provincial legalism. You will define it in that way, this kind of like trying to maintain your culture while being absorbed in the empire or something like that. I don't know if like I'm defining it in a very shallow.
Yeah, actually, I want to be very open about what local legalism is. I'm still trying to fill that's a category that I want to fill through this project. I'll just emphasize that I think that the first step is to release ourselves from the Roman perspective. So I think that even scholars that are very much committed to enhancing the agency of local agents and telling, hey, they're creating something, on the whole, are looking at it as this trajectory of becoming more and more Roman. What are the stages? Who is participating in this process? Now, the Jews, I think, are only half participating in this process. So it allows you to wait a little bit, not to see this as part of a general trend, but to wait a little bit and think, when we're still in this intermediate stage, in a sense, what exactly are the kind of considerations, practices, values that we're including? So I thought of this notion of, I would say, provincial legalism. Again, because it's a legalism, it's a way of thinking. It's not only a practical instrument that litigants apply. No, this is a system. This is a cultural system. So this system is developing new ways of defining itself. And this is, and now this is something that I very much owe again, there's nothing new in it, but really to the study of cases of more early modern or modern cases of indigenous law in colonial empires. So what you see there, and this is something that struck me when I started trying to, I'll put it this way. I was standing in front of a paradox. I could not understand how come rabbinic law developed to such an extreme, to such a system, sophisticated legal system, particularly when it came under Roman rule. You would think, and I think people intuitively think always the opposite, right? You would think that as when you have your own power, when you have your own state, like the Jews basically had during the Second Temple period, although you had Rome in the background, but on the whole, they could maintain their own legal institutions and even the high court, etc. So you would expect that a legal autonomy generates a sophisticated legal thinking, jurisprudence. But at least the rabbinic case is the opposite. As long as we're in the independent state of Judea in the Second Temple period, there's nothing. Again, it could be only by chance, but I don't think it's by chance. I think that you don't need to, you're not defining your law in this juristic manner. Since you have these traditions, you don't see law as a specific, particularly a sensitive arena. And when you come under direct Roman rule, suddenly you have to define yourself. This is something that we see again in colonial cases, right? When the language of the British Empire, right? The law that the empire brings with it, it doesn't impose it on the indigenous groups, but it requires them to restructure their legal thing. So here we have someone that is using imperial idioms, we would say, of law, of legal system, of juristic thinking to develop a system which is not independent, which is actually very, very weak and does not have any force. And the way it tries to convey itself to its own community is by the language of law. Right? Saying, hey, we have something. We don't have the power of Rome. We are not able to enforce like the Roman governor will be able to enforce, but we are able to present ourselves in a very sophisticated manner. So competing, at least on a cultural level, with our surroundings. So provincial legalism is something that when you develop a language of legalism while trying to fit within as I would say, a secondary system of law. This is so. Let me just bring another example. The fact that during the 2nd century, and this is something that I was surprised to find out, the rabbis developed this legal system on the whole during the 2nd century, and this is exactly the period where other groups are starting to develop an identity, or other elites are starting to develop an identity as experts of law, the nomikoi, right? The local jurists. And nomikoi are a very important aspect, but they begin only in the 2nd century. And again, while local elites had different ways to convey their status and to support their communities and etc., they add this notion of juristic status during the 2nd century as a reaction to Roman legal administration.
Just to clarify for our readers, because we are talking about, what happened when Rome arrived, but what was the situation of rabbinic law before? It didn't exist at all? Was it scattered? Was it influential for the local people, or what was the actual situation?
So we have to, you're right that we have to.
Yeah, we are talking about the aftermath. We need the before.
No, you're right. And the problem is, I'm assuming here many assumptions that I have to be very honest and make more explicit because some scholars would disagree with my assumptions. So on the basic level, there is no legal literature dealing with fields of private law before the rabbis. Okay, so if the rabbis begin from the 1st century, more or less, and we have the Hebrew Bible. Let's take the Pentateuch. the book of Exodus, which and the book of Deuteronomy have portions that are deal on a much more limited level, but they deal with issues of cases of monetary or cases of injury or cases of loans. We have some things that we would call private law in the Hebrew Bible, but it was not. While other aspects of law, let's say ritual law, was very much developed during the period after the Hebrew Bible. Let's say during the Second Temple period, the centuries before, I would say the 4 centuries BCE. So these, while some fields of law were developed and became also a crucial element within Jewish society of that period, the fields of private law on the whole remained outside legal discussion. So legal writings, and we have some legal writings, and we have legal traditions from the Second Temple period. As far as I can tell, they almost don't deal with that at all. They do deal a little bit with laws of marriage, but aspects of laws of marriage which are not the monetary contractual aspects, but more issues of the prohibitions of who is defined as married and what is divorced. These are issues that are more ritual, have a more ritual aspect. Marriage and for sure other elements of contracts and sale and working, all that. Simply, they don't have anything to say about that. Obviously, like all people, they had interactions, right? They had to deal with these things. How would they deal with them? We don't know. What we probably do know is that they didn't feel that it was something uniquely Jewish, that there was a Jewish way to solve these kind of issues between people, that if the Hebrew Bible has something to say, it's more of a moral message, that you have to be kind, that you have to make sure that you're not cheating, that you're helping your brother. I mean, let's put it this way. If you read the New Testament or you read the kind of statements that Jesus says in the Gospels, so then you can really feel how Jews of that period related to these issues more as moral issues and not as legal issues. The rabbis are the first ones, as far as I can tell, that transform this field into a legal field. And why are they doing that? The best explanation, in my view, would be that they view this as part of the law, as an essential part of the law, as a uniquely Jewish alternative to the Roman to the Roman practice. Now, again, this is my own theory. Others would say the fact that we don't see literature on private law in earlier stages doesn't mean that they had no such laws, and maybe the rabbinic traditions are much earlier. But I think the evidence for that is quite weak.
Well, I think you propose a very interesting hypothesis, and evidently you have 5 years now to develop it, so we will see what are the reactions to that. But my question then will be of the aftermath, meaning like, now that the rabbis have created this body of law to assess this kind of identity, the impact of this will be only on the local Jews, or do you think Roman law also, takes something from this?
I should be very careful in assuming the force of rabbinic law, or it's the kind of influence it has. There is a process that scholars call rabbinization, in a sense that the rabbis have a growing influence on Jewish society, and we can see that during the 3rd century there is a growing influence. But what it's more important for me not to prove the influence of rabbinic law, but to check to what degree is rabbinic law representative of processes that we find among other communities. So within this project, I want to see how much can we integrate our knowledge of rabbinic law to scholars of other fields and tell them, look, let's think together. Maybe what you're dealing with the Roman Greek cities, you're dealing with Egyptian law and the development during the first centuries. I'm dealing with rabbinic law, which clearly is a unique case, right? But still, are there elements that all communities share? And in that sense, we can talk, and that's another element of what I would call provincial legalism, because each has its own way of dealing with the situation. But if they are all dealing with the same problem, they're all sharing on some level some kind of discourse. And we can see that. I can give some examples just to show that how much, let's ask a question such as, how much knowledge of Roman law was there in the provinces? How much did non-Romans know Roman law? And what were the channels through which they were exposed to this law? This is a crucial question in trying to understand how people are dealing with this situation. Are they aware only, if we start from Babata again, from the archive of the woman Babata, we didn't say anything about her. We should maybe say another few words about this very important woman, right? Otherwise, we would know so little about the legal situation in Judea during the beginning of 2nd century. So this woman and her archive that was found in the Judean desert. So there are multiple, again, combinations, as I mentioned. Tchaikovsky says it shows that in the same document you can find a Hebrew element, a Hellenistic element, and a Roman element are all combined together, and that's really part of the way she's dealing with it. And we also have translations of Roman actio, right? The formulae that you would use to approach the judge according to the Roman procedure. Now, she's not working through a Roman procedure, but she's doing her best, right? As we said before. And that includes knowledge of a text that we know from Gaius. Now, Babata surely didn't read Gaius, that's clear. But also the person that translated the actio for her didn't know Gaius, but he must have known the praetor's edict or something of the sort, which would list the kind of procedures that we could bring to the Roman judge. So this is one way, again, from a judicial perspective, looking at the kind of exposure. But when you read rabbinic law, and this is things that we only recently are beginning to uncover, and I hope the project will continue to uncover, we see the kind of knowledge that is much more than we would expect, that is textual, a knowledge of legal textbooks, or what's, I would say specifically, legal handbooks. Right? In an article that is a forthcoming article of mine in Law and History Review, I argue that portions of the Mishnah that are unique, that are different than other portions are different than parallel portions of the Mishnah, we find a structure of a topic such as presented in the first book of Gaius or in Pseudo-Ulpianus. And we also have the taxonomy regarding status of newborns. The Mishnah has a taxonomy, a very unique, problematic taxonomy of how do you define the status of a newborn? Does he follow the father, the mother, the one in the lesser status, right? We have all this system. And this is, again, it doesn't copy Roman law, but it uses the taxonomy that you could have learned from these legal handbooks. Now, it's not impossible. It makes sense. We're talking about a period around the end of the 2nd century. Soon enough, we'll have a law school in Beirut, very close to the Galilee where the rabbis are acting. When the rabbis have some kind of contact, probably with the Severan dynasty, right? We know Septimius Severus was around here in the Galilee. We know there are a lot of reasons to assume that there is kind of spread of knowledge, again, of Roman law, that those who are heading the administration of the Severan dynasty are jurists from the East. So suddenly we have to rethink how the province looks. And you have rabbis which don't read Latin, but create a text that is parallel and has points of affinity. And you think this makes you rethink again. I don't have a clear image yet, and this is exactly the kind of thing I want to think about. But suddenly we realize that the rabbis, we always saw them as something quite marginal or closed. They're talking their own legal discourse, but they're somehow participating in intellectual may be discourse that is wider, that is shared by other jurists of the period, both local jurists and Roman jurists. So again, what is the how should we map out this kind of relationship? And I think again, the more than we're asking, what is the impact of rabbinic law, and that's something we really have difficulty to answer, because there are no historical texts telling us about the rabbis teaching or their laws to others, or that people are following. We have rabbinic literature.
Mhm.
It's like an internal system of the internal literature, and we don't know how much people are using it or coming to the rabbis. It seems as though the third century they become a more significant on a social level, but yet we have to be very careful. So while we cannot reconstruct exactly the ways the rabbis are acting, exactly their social status, exactly the way the law they're making is disseminating in their surroundings, we can more and more, I think, say confidently that they're participating in this local legal discourse. And now we have to rethink about what kind of discourses is it that both the rabbis that are not Romans, even before being a Roman, even before 212, have an deep interest of learning and replicating on some level.
You're again like driving into a lot of topics. In fact, something you describe in a very simplistic way, I describe to my students as the broken phone. Basically, when you're in the province and you're copying a formula that was released somewhere in Rome, or because we don't really know that much about the provincial edict. Actually, we don't really know how it looked. What
Right.
if
Right.
it was actually a copy of the Roman or it was its own thing. I understand this kind of situation with Babata. She's trying to do whatever she do the best because it's for her son, and she needs to access this guardianship. So it's very interesting. And what I'm wondering with what you said about the rabbis, okay, they are learning, they are doing things, but is there any kind of, I will not say industry, but kind of like offices, like developed in this kind of like notarized practices? I mean, like in Egypt, we see that is very developed, and all that. But I don't know if Egypt is also, again, like a very peculiar case. I'm wondering in this period and this area, when they are developing these corpuses and of theory and, and institutions and that, is there any kind of like documentary practices that develops from that?
That's another one of my questions. I can't give you a clear answer, but I will say something intelligent just to answer. So I won't. So at least I'll say something interesting. When we compare the Mishnah to Babata, it's very, very interesting, because on one level, we see that the Mishnah, in the section dealing with marriage agreements, what's called in Hebrew ketubah, the Mishnah lists a whole list of passages that must be included in a ketubah. And these exact passages appear in the ketubah, in the marriage agreement of Babata herself. And that is amazing, because you see that the rabbis there's a close affinity between the rabbinic law and the actual practice. Now, Babata's ketubah is not the only form. We have similar ketubot, which unfortunately were not preserved as well, so we can't know. But on the whole, there is some variety. But the fact that there's someone that is exactly following the same kind in the same order of passages in the rabbinic Mishnah is amazing. Now, how would we interpret that connection? One thing would be to say that Babata is following the rabbinic law because it's written in the Mishnah. But if we read the Mishnah carefully, I would say that almost the opposite, because the Mishnah, the way it formulates this law, it says that if one does not write the following passage, such as that the husband is required to feed the wife even after his death until she marries or until she leaves the house or marries a second husband. This is exactly, we have this passage. Or that he has to feed the daughters and has to divide the sons, the wealth to the sons. Again, we have similar passages. Now, but the Mishnah says that if one did not write these passages in his own agreement, he is obligated anyhow to fulfill it, because it is considered a court's decree, a court's decree. So that So what are we what is the Mishnah imagining? The Mishnah is actually imagining people that are not writing these I would say traditional passages. So Babata in this sense is representing some kind of tradition of how to write the Ketubah, and the rabbis are worried that some people are not doing it. And why are they worried? For a very simple reason, because they live in a reality of legal pluralism. We're returning back to our point of departure. They themselves know that people have not only multiple ways of writing a ketubah, but some of them follow the Greek practice, what's called the Greek custom. And how do we know that? Because in the same archive of Babata, we have Babata's ketubah, which is a Jewish traditional and the whole, relating even to biblical instructions. And we have a Greek marriage agreement, which is completely different. Its principles are different. It reflects a different kind of economic relationship between the parties, and it's similar to the kind of agreements we would find in Egypt or the Greek tradition, we would say. The Greek dowry tradition, I would call it this way. Now, so what do we have? We have multiple practices, and the rabbis are aware of that. And what they're trying to do is not to determine what should be the scribal practice. Scribal practice is something that is assumed, is a given. What they're trying to do is, how are we supposed to deal with the multiplicity of practices? And here's another element of what I call local legalism. And this is a term I would say consolidation. What do you do? The rabbis are really trying to maintain the Jewish practice. And they say, okay, if you're writing a Greek contract, you should know that at the same time, the passages that you have not written you're still obligated to maintain. And so now we can combine. And the result is a very complicated system of obligations that we have in the Mishnah. Again, I was wondering, for many years, I was trying to learn and understand, why are the rabbis creating the most complicated system of marriage agreements? I mean, if you can compare it to other systems of antiquity, as far as I can tell, it's the most complicated. So you can say that the rabbis like to go the most complicated way. It's a rabbinic way of thinking. But I think it reflects the situation of a local, weak community that is trying, first and foremost, to deal with the fact that it's exposed to multiple systems, and trying to make sense, to try to combine these many aspects. So I would say, put it this way: if Babata is combining traditions in the one document she's writing, the rabbis are combining more systematically, from a juristic point of view, multiple systems in their own rabbinic activity. And I think this is, and I see a few examples of that within rabbinic law. And this is something I would want to see, how much can we see this kind of tendency within other local practices. Again, a tendency that is incoherent, that is cumbersome, that tries to combine multiple traditions into a specific practice. And again, that is something that reflects, as far as I can say, not a governing power. Because if you're the ruler and you have the power to determine law, you have the way to systematize it. But if you're only reacting, you're on a secondary level, you're reacting to powers that are coming from various directions, the result would be a different kind of legal discourse.
I'm happy to hear that, they are aware of this pluralism, because, I work mostly with trade, and I would really like to know what you come out with, commercial practices, because they are really legally plural.
The only thing I can say that I'm waiting to hear your own insights and to continue our discussion outside the podcast about these issues, because I really want to learn more about that. It sounds really fascinating.
Yeah, no, indeed. We will talk more about that. But has been one of the things I would like to do, to go to Jerusalem, actually, because you have a lot of material that is there to study, on fish sauces and stuff like that. And one of my questions is actually if merchants are aware of this plurality, that I'm starting to think that they are, if they know that much about law as your rabbis. But I have only a couple more questions, if you're okay with that, and then I will be off your back. Is it okay?
Sure, I'll just tell you that talking about merchants, in an article by Catherine Hedger, when she asked the question, did the rabbis know Roman law? One of the cases she brings is a source about issues of merchant merchandise being shipped, and is saying it's clearly not by mere chance that it's specifically in these international exchanges that the rabbis reflect much of this knowledge. But again, I don't have a systematic image yet of the kind of how they deal with this the field as a whole.
Pools in the future. But this maybe is a bit of a naive question. It came out of my head when you were explaining. You mentioned the School of Law of Beirut being very close to Galilee. Do you really think the rabbis maybe they could have, assisting there to learn a little bit more about Roman law, or this could not be a possibility?
No, I don't. Again, I do not assume that they know Latin, and they most of them don't even know Greek that well. So we don't have enough evidence to assume that. I prefer assuming that there's some kind of oral knowledge that's going around, and it fits more my image of the rabbis. But let's take a small example on the fact. At least when we get to the 4th century, so we know that the son of the patriarch is learning rhetoric in Antioch with Libanius. So maybe the rabbis themselves are not that knowledgeable or don't have direct contact, but there's enough in their network that can carry this kind of knowledge. But again, this is an essential element when we talk about what do we do, and this is a methodological issue. What do we, as scholars of rabbinic law, Roman law, Greek law, Egyptian law, do when we are aware that we know so little? We should always remind ourselves that we know so little about what happened, and now we have to fill in the gap.
Yeah.
So I try to be careful and not reconstructing this whole image when I don't know so much, but using the kind of parallels between different practices can help us create this larger image. But if you'll find any kind of evidence of a rabbi we have rabbis in Caesarea, we have rabbis that we know that are no Greek, that are in contact with the governor. Those are the kinds of things we can say. But Beirut, no one ever mentions Beirut as a place that they go to study.
Yeah. No, I just wanted to wonder about that, actually. But in what you're saying about the evidence actually coming from an archaeological background as me, I think you're very smart when you said we don't really have anything before then. Absence of evidence sometimes tells something. Obviously, we cannot assume everything.
I agree.
But that is something to say. Sometimes we only look for the evidence, and it's, So my last question, and coming from the very, very start of this conversation, will be, and I'm sorry because this is a very topical question, what do you think will be the impact of the Constitutio Antoniniana here, or if there is an impact?
Yeah, that's a fantastic question. This is one of my aspects of my project has to be that. What can we say about the Constitutio Antoniniana from the rabbinic perspective, or what does the rabbinic perspective add to this question? And clearly, I can say that on some level, you see the rabbis really more Romanized. Rabbis of the 3rd century on some level, they're more Romanized. And I can bring some. I don't want to drag too long into examples, but you know what? I'll bring one example. It's very interesting that there are traditional Jewish forms of manumission, of the way you release slaves.
Yeah.
Right. And the Mishnah talks about that a lot. And it's clear. The system is clear in early rabbinic law. And suddenly in the 3rd century, maybe early 4th century rabbinic text, they suddenly ask, does a new form of manumission work? Now, this form, again, we have to remember that it's written in Aramaic, in Hebrew letters, Aramaic text, which is trying to reflect a Greek term, which is a Greek form of a Latin term. So if we go all that trace, and scholars have done that, if we trace the whole way from the Hebrew text, and again, that could have been completely mistaken, but it's manumiso vindic. It's a form of Roman manumission. Now, my analysis of that text argues that the rabbis are aware of the fact that this is a new form of, new for them. And this is a new form of manumission, and it's relevant for them because now they are also Roman. If you are a Roman owner of a slave, so when you manumit the slaves, he becomes both Roman and becomes Jewish. It happens at the same time. This is a very interesting fact because also Jewish law assumes that when you release a slave, he becomes a Jew. And Roman law argues that if you do a formal way, not a informal way of manumission, but if you do a formal way of manumission, the slave becomes Roman. So now we're in a problem. If I'm Jewish and Roman after 212 and I manumit the slave according to Roman practices, has he also become a Jew. So these are very interesting, and it's interesting that specifically, if we had more time, specifically in the field of personal status, there's a lot of interaction because you feel that people define their own status according to principles of the society they live in. So this is a case where I would argue that this is a question that could have been created only after 212, right? Because that reflects the kind of concern of a Jew who is also Roman. And we have also cases of legal procedure that you have to follow Roman, and the rabbis acknowledge the fact that you have to follow Roman procedure. So again, we still have to collect evidence, and it will be very, very piece by piece. We're not gonna find anything immediately substantial, but maybe I think we can find evidence for what it means for someone that is maintaining its own legal system, and the rabbis are clearly maintaining their own legal system, but are aware of the fact that on the whole, they are also obligated to Roman law. So we know now, and we know that from the Egyptian papyri, that local practices continued, and only specific issues were on the margins. These issues have changed. But I think the more interesting issue is, can we identify the kind of awareness, the kind of consciousness of a person that has a commitment to his own tradition, but at the same time understands that he is part of a Roman, I would say, Roman law, and that's why he has to somehow sometimes explain his own practices in Roman terms.
Yeah, this looks like life became way more complicated, because then you have two identities, and you're a pro-Jew, but then you're a Roman too, and it's like I'm very interested on this kind of processes as well. There is right. This I think it's this sermon by St. Augustine, when when Rome has fallen, and the people come to his church and say, but we are now Christians and we are Roman. What is this happening? What do we do now with our identity?
Fantastic.
Yeah.
Right.
And I can imagine these Jews, these rabbis saying like, okay, now we are Roman. What do we do now? What is going on, right?
We don't see I don't see any identity crisis. After all, they're still waiting for Rome to fall and for their own, I would say, their own eschatological hopes to be fulfilled. But on a very practical, but that's only one dimension. On the very practical level, that's a very good question. What does it mean to be Roman in the 3rd century? I think that's the question that we must ask about the inhabitants of the provinces at that stage.
Yeah, no, I think it's a very good question. I think it's very interesting, but unfortunately, we don't have time for everything. So I will need to, ask if you have anything else that you're working on that you would like to plug, even if it's not related to the ERC, it's okay. Is there any article, anything that you would like to mention for our listeners that, they could be interested on?
I'll just say, I mentioned the article forthcoming in Law and History Review, which I think is like a good starting point. But I really look forward. I'm planning it, but I'm really looking forward to developing this, I would call, database of local practices under Rome. This is one of the major aspects of our project. We want to go deep, like we started doing in this discussion, but we also want to go wide to see the whole picture. I really see, again, coming from a rabbinic background and also taking Babata as an example, in other cases, we cannot study one legal system separately from all others. I mean, if you are a student of Roman law, so you assume, we have the Roman tradition, or we have the Jewish tradition, but it simply doesn't work. You see that it doesn't work. Things are they're entangled. That's the idea. So what is the level of connection between different systems? This is a question that I'm really, really excited to continue to work on, and the result, and will take some time, but I'm looking forward for that. The result should be some kind of database where scholars or whoever's interested in the ancient world could come and get a better understanding of what it means to live within this, what we call legal pluralism. What is the relationship? What are the connections between each system? Because the history and the context and exchanges are really very, very rich. And they're the main force that develops the local systems. So I look forward for this database. Again, Local Law Under Rome is the name of the project, and we'll produce things under this name. And I hope the audience will be able to appreciate it.
I really hope so. So I'm looking forward. If I didn't mention, they are starting the work actually next week. So this is fresh from the oven. We're going to be actually when your starting point. And I really hope that, I'm looking forward to the results, but also I'm looking forward for this database because I think it will keep each other talking. People from different specialities, as you said, Greek law and, like Roman law and all that, because sometimes even if we all study antiquity, it is incredible how segregated we are. We deal with
Absolutely. I must say, so another, just a personal note. I feel like Jews in the provinces felt under Rome, also a scholar of Judaism many times feels on the margins because why should others from more dominant fields be interested in what this small group has to say, right? So in a sense, I really, I identify with what you said in our need to continue to have a possibility to know each, the different systems and to be in contact through the different disciplines. And that's a real, I think, again, here is a real experience of this kind of provincial cooperation, to being part of this large, I would say, intellectual endeavor.
Yeah, we will look forward to that. We will keep in touch. And again, thank you very much, Yair, for being here with me today. And I look forward to look at your results. Thanks.
Thank you, Emilia. It was such a pleasure. Thank you.